Yet another snag hit the resumption of the Senzo Meyiwa murder trial this morning as court began after a 2-week recess. Accused number 3, Mthobisi Mncube, wanted proceedings suspended over his continued incarceration in solitary confinement at the Kgoši Mampuru Correctional Facility in Pretoria. Mncube's lawyer, advocate Charles Mnisi, telling the court that his client would even go as far as wanting a separation of trial to allow him to bring an application over his prison conditions since 2020. Mnisi was initially due to cross-examine ballistics expert Malesela Ntini. SABC News senior reporter Chriselda Lewis has more for us. Chriselda?
Indeed, Bongiwe, you'd recall that the conditions in prison where accused number 3, Mthobisi Mncube, is incarcerated have previously come up. So instead, indeed, of the cross-examination of ballistics expert Malesela Ntini getting underway this morning, advocate Charles Mnisi for accused number 3, Mthobisi Mncube, told the court that Mncube wanted the trial suspended to allow him time to bring an application regarding his incarceration conditions in solitary confinement since 2020, you'd recall, when he was arrested. So Mnisi telling the High Court in Pretoria that his client was mentally drained and that his conditions in prison were unfair and a violation of his rights. Let's take a listen to what was said there.
Mr. Mncube instructs me that it has come to a point where he can no longer take it because he has been in that situation that I explained before the recess for 4 years.
Yeah, great.
And now that it is indicated to him that unfortunately there is nothing that can be done in the meantime to assist him, and the only way through which he can be assisted is for him to bring a substantive application before another court to challenge his situation.
Yes.
He therefore requests, my lord, that this trial should then stop.
Stop?
Yes. It is his request. Those are my instructions. That is what he's instructing me.
I know there's a political party which wanted to stop.
Maybe the word stop it's another way, but then that the continuation with this trial be suspended in the circumstances, my lord, to afford him the opportunity to contact his family, which he does not know how he's going to do it, to try and find out on his behalf if there's an attorney and an advocate who will be willing to bring that application for him. Because he is saying further, he will not be in a position to start to drive or to prosecute that application when he's also concentrating in this case. And most unfortunately as well, my lord, I am also not in a position to assist in that application when I'm also supposed to be concentrating on this case. I can't be expected in the afternoon to go and assist in the drafting of papers, also prepare for the following day to come cross-examine and listen to, to analyze testimonies of witnesses and cross-examine them in this case. That will further perpetuate the injustices that he is complaining about, because then I will have to share my concentration. Fortunately, I would not be able to confront two fronts from different angles, my lord. I mean, to confront two fronts at a go. That I will not be able to do.
So you're saying this trial must be terminated because you don't want to, you have used the word stop.
No,
so you're saying it must be terminated. What are you saying?
No, my lord.
What are you saying?
As I said, probably the word stop came out in a rather unsavory way. He's basically requesting that he be afforded the opportunity to try and get an attorney and an advocate through his family that is going to assist him. But the unfortunate part is he will not be in a position to do that when he's also attending this court. So that means for him to be able to fight the battle, which is such a mammoth battle that he's supposed to fight, is for this trial to be suspended for a
For how
while.
long? Suspended for how long? Let me tell you, I've never ever heard of a trial which is suspended on those bases.
So as you heard it there, Judge Rata Mokgotleng having none of it, and this was even continuing even as a separation of trial was brought up by Mncube's lawyer advocate Charles Mnisi. Let's take a listen to that part.
The interests of justice don't allow that request. I can't. In this case, there are 4 or 5 accused persons before me. There are the complainants, there are the witnesses, even myself. I can't be sitting in this case until I die.
Maybe, my lord,
So,
my lord, in those circumstances, because this is a situation sui generis, probably it will be a justification. Now I'm thinking out of the box. It will be a justification to apply for a separation of trial then, to afford him the opportunity to go and attend whatever that he wants to attend. Meanwhile, the trial, so that to prejudice the other accused with the continuation of the trial.
If you say you want the separation of trial,
yes,
what happens to the evidence which has been led? I've never heard. I've never heard of a separation of trial at this late stage. Never.
But does the court really understand, my lord?
I do.
To stay in solitary confinement.
I do. That's why.
For 4 years. What does it do to the mind of a person?
That's why I became concerned.
Yes.
I engaged the JP. I engaged the Directorate of Inspections. And I even went to the law. And this is not a difficult application, please. It concerns a Bill of Rights. That's all it concerns.
My lord, it is so. It might not be a difficult application to a person who knows the law. Yeah. But to a person like him,
you know the law.
But I've just indicated, my lord, that I'm not prepared even with an inch to concentrate in this trial, at the same time be involved in a separate substantive application, which has got to do with his housing. That I'm not prepared to do.
Fine.
And if I'm not prepared to do it, my lord, then he then has got to do it himself. That is where then that notion of to draft an affidavit for in terms of a person who knows the law might not be a tedious thing, but to a person who knows the law, such as him, it's going to be very tedious.
Yeah, he's going to instruct a lawyer, obviously. Okay. I'm sorry, I can't accede to any of those requests.
So Judge Mokgotleng also adamant that his hands were tied and that Mncube needed to bring an urgent application. So this has Mncube also questioned why he was the only accused in this case that was in solitary confinement. Let's take a listen.
My instructions are that he has been in custody in solitary confinement since 2019. People have come in and went out. People who have reoffended whilst in prison, they've stepped police and everything. They've stepped other inmates, they went in and went out. Now, apparently he is told that one of the reasons why he should be kept in solitary confinement is because of this case. Now, his question is, some of his colleagues that is also attending with in this case, that is co-accused, are not in solitary confinement. So why should it be him that is in solitary confinement because of this case, when other accused that are also involved in this case are not in solitary confinement? He still insists that may the court please have passion, mercy, and compassion to allow him an opportunity to go and think of a situation or of an idea on how best could he tackle this situation. Because he says, my lord, he cannot even concentrate here at court, because each time he comes here, he's got to think about his conditions where he is housed, as to the reason why is this injustice actually being perpetrated. When he leaves here, he hardly has got time to think about what has been happening here at court. for that day, because he spends most of his time in solitary confinement thinking about his agonies. He's basically agonizing about his stay there.
No, fine, I hear that. He must bring an urgent application. He's got the right to do that.
In the meantime, what should then be happening? Because I've got no instructions
in the meantime, there's nothing
to cross-examine this witness.
No. In the meantime, there's nothing this court can do, because the Commissioner of Correctional Services has made an order. Am I correct, Mr. Balui?
Yes, indeed. And we try to the best of our ability to mediate, but it's about separation of powers.
So that order must be set aside.
Yes, they exercise powers in terms of the Correctional Services Act.
That's it, yeah.
And
there's nothing this court can do.
There's much we can do.
Okay, can you just start with
this is the message, my lord. The court cannot compel me to start, my lord. I'm a creature of instructions. If I don't have instructions to start, I can't start. But this is what he's saying.
Mr.
Yes.
Are you saying if your client says you mustn't start, you're not going to start?
No, but my lord, I
no,
need to have instructions. I cannot act against his instructions. And this is what he's saying. Ikoto uma ifuna ukuqhubeka ngenkani yayo ingaqhubeka. Kodwa mina yazi ukuthi ngihlukumezekile engqondweni. Ngicabanga indlela engihlukumezeke ngayo. Those are instructions.
I sympathize, and I'm very human about this situation. That's why I'm saying we can bring an urgent application against the Correctional Services, the Minister, the Director, and they can even cite the Department of Justice also.
All right, as a result, cross-examination only began at 2 p.m. with Advocate Charles Mnisi grilling ballistics expert Malesela Ntini on his microscopic verification of his colleague, Colonel Chris Mangena's work. You'd recall, Bongiwe, that Mangena linked the gun allegedly confiscated from accused number 3, Mthobisi Mncube, to the bullet that was found at the Senzo Meyiwa crime scene, and even at some point, Advocate Mnisi referring to Ntini as a hired gun who was towing the line of the state.
And of course, Chriselda, thank you very much for that comprehensive update, and we'll continue to watch this particular story.